Hey again, Facebook friends, family, YouTube people. I watched that video with Donald Trump and that guy from Univision. The reporter says you can't deport 11 million people. Well, it would be hard to do, yeah, granted. Be very expensive. But however, I think I found the answer from doing a little research on this problem. I was looking up the 14th Amendment, and I was curious as to what some of the words meant, because I wasn't sure how they are interpreted or being used, and it's been figured out. So I'm going to read a few things to y'all, if you don't mind. I know most of you don't watch my videos, but I did post it in writing on the on Facebook here, on that Donald Trump video. So let's see if I can get this so people understand, okay? Give me just a second here. The phrase "subject to jurisdiction thereof" was intended to include American-born persons from automatic citizenship whose allegiance to the United States was not complete. With illegal aliens who are unlawfully in the United States, their native country has a claim of allegiance on the child. They're talking about anchor babies here. Thus, the completeness of their allegiance to the United States is impaired, which therefore precludes automatic citizenship. Period. Okay. Now we're going to go to another one here. A Supreme Court decision. And this really clears it up for a lot of people. Okay, the correctness, this is a Supreme Court decision. The correctness of the 14th Amendment is that an illegal mother is subject to the jurisdiction of their native country as her baby. Okay? Over a century ago, the Supreme Court appropriately confirmed this restricted interpretation of the citizenship of so-called slaughterhouse cases. 83 U.S. Code U.S. 36, 1873, and 112 U.S. 94, 1884, Section 13. In the 1884 Elk versus Wilkins case, the phrase "subject to its jurisdiction" was interpreted to include children of ministers, councils, and citizens of foreign states born within the United States. In Elk, the American Indian claimant was considered not an American citizen because the law required him to be not merely subject to some respect or degree to the jurisdiction of the United States, but to completely subjugate to their political and jurisdiction, owing them direct and immediate allegiance. The court essentially stated that the United States, or the status, let me reread that. The court essentially stated the status of parents determines the citizenship of the child. To qualify children for birthright citizenship based on the 14th Amendment, parents must owe direct and immediate allegiance to the U.S. and to completely subject to its jurisdiction. In other words, they must be United States citizens. Congress subsequently passed a special act to grant full citizenship to American Indians who were not citizens even though they were born within the borders of the United States. The Citizens Act of 1924, codified in 8 U.S.C. Code B 1401, provides that the following shall be naturals and citizens of the United States at birth: a person born in the United States and subject to the jurisdiction thereof, a person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe. In 1898, the Wong Kim Ark Supreme Court case, once again in a ruling based strictly on the 14th Amendment, concluded that the status of parents was crucial to determining the citizenship of the child. The current misinterpretation of the 14th Amendment is based on part upon the presumption that the Wong Kim Ark ruling encompassed illegal aliens. In fact, it did not address the children of illegal aliens and non-immigrant aliens, but rather determined an allegiance for legal immigrants' parents based on the meaning of the word domicile. Since it is inconceivable that illegal alien parents could have a legal domicile in the United States, the ruling clearly did not extend birthright. Okay, let me get this done right here. Okay, citizenship to illegal alien parents. Indeed, the ruling strengthened the original intent of the 14th Amendment. The original intent of the 14th Amendment was clearly not to facilitate illegal aliens defying U.S. law and obtaining citizenship for their offspring, nor obtaining benefits at taxpayers' expense. Current estimates indicate that there may be between 300,000 and 700,000 anchor babies born each year in the United States, thus causing illegal alien mothers to add more to the U.S. population each year than immigration from all sources at an average before 1965. American citizens must be wary of elected officials voting for illegally extended our generous social benefits to illegals and other immigrants or other criminals. Now, this came right out of the Supreme Court ruling. So I think that straightens everything out. It should, is the way I'm seeing it, folks. So anybody's got a problem with it, they'll have to get the 14th Amendment amended, because this is the way it works. And the thing that really breaks my heart is it took us till 1924 to make the Native Americans or American Indians citizens. Technically, before that they weren't, which to me is a bunch of crap. But however, that's the way it worked. So anybody that comes into this country illegally is a criminal, period. And your child, if you have one born here, is not automatically an American citizen. It's simple. It's in black and white. It's written down. The Supreme Court has ruled on it. There's nothing else to be said. You're here illegally, you are a criminal. Thus, having a felony upon your head, you can never become an American citizen. Simple as that. I mean, you couldn't get it any plainer unless you walked up and smacked somebody upside the head. Well, that's my little rant on this, and hopefully I've illuminated some people, and I know I pissed a lot of people off, but I'm just reading what's written. Don't shoot the messenger. The truth is there. All you have to do is dig it up and look. Y'all have a good day, Facebook people. God bless. And you people in Washington and Oregon, my prayers are with you, and my heart goes out to every darn one of you. This should never have happened, and we can thank our Forest Service and Bureau of Land Management for all their stupidity. We've got college-educated idiots that wouldn't know a pine tree from a cactus if it walked up and bit them. Y'all have a good one. Take care.